Ready, start. As regards the letter dying declaration, the High Court has remarked that it is not noted in the case diary of the investigating officer. It was the light of the day sometime after September 26, 1969. The High Court observed that Ari Beg's condition was not very good when the investigating officer recorded the dying declaration. It appears that his condition was serious, so the Tahsildar magistrate was called for record his dying declaration. The Tahsildar, however, returned without recording it as, according to him, the condition of Arif Beg was very serious and he was losing consciousness every moment. Dr. S.P. Jain, however, recorded his dying declaration a little after the Tahsildar had gone back. The High Court has also noted another disconcerting circumstances. Majid Khan, brother-in-law of Chitu Beg, was all along with Arif Beg. Majid Khan himself bore enmity with the appellants. He had accompanied Arif Beg from the place of incident to the hospital. He was present when the dying declarations were recorded. Arif Beg was 12 years of age. It is true that Majid Khan has denied that he had tortured Arif Beg to name the appellants, but his denial should not inspire confidence because Arif Beg undoubtedly incriminated two more persons as assailants in the dying declaration made to Dr. S.P. Jain, while in the dying declaration made to the investigating officer, he has named 5 persons: Majid Beg, Aziz Beg, Rashid Beg, Wahid Beg and Mosib Beg. In his dying declaration to Dr. S.P. Jain, he has implicated Aziz Beg, Wahid Beg, Wasir Beg, Mazid Beg, Masid Beg, Noor Beg and Rashid Beg. In the later dying declaration, he has thus implicated 2 more persons, Basir Beg and Noor Beg. Legally, a dying declaration which should inspire confidence may be sufficient to hold guilty the persons accused therein, but in view of the circumstances already indicated, we think that it is a case where the 2 dying declarations should not be believed without some corroborative evidence. The sessions judge could safely rely on them because he had already believed the oral evidence of Sardar Beg. The High Court has rightly discarded the oral evidence of Sardar Beg. In the result, there is no credible evidence to corroborate the dying declarations. It seems to us that the High Court also felt some difficulty in convicting the appellants for want of credible evidence to corroborate the dying declarations. The High Court said whatever the condition of Arif Beg may be, whether there was some improvement or not, the condition when the sub-inspector took the declaration was not very good, as also the condition when the doctor himself recorded the same. It may be that the gained consciousness we feel that it will be safe to accept the names of the accused persons common in the dying declarations made to these 2 persons sub-inspector and medical officer to hold that they took part in the assault on Arifpet. The word feel has an air of uncertainty. We are reluctant to approve of his mechanical test of the greatest common measure in the two dying declarations to fasten guilt on the appellants, for there are certain suspicious circumstances which should require dependable evidence in corroboration of the dying declarations. As there is no such corroborative evidence in support of the two dying declarations, we think that it will not be safe to maintain the conviction of the appellants. Accordingly, the appeal is allowed and the order of the High Court convicting the appellants is set aside. They shall be released forthwith if not required in any other case.